All right, let's dive into this explainer. We're going to unpack a truly bizarre political workplace drama from back in 2002 that literally spilled all the way into South Africa's highest court. We often think of constitutional law as a super dry, heavily theoretical textbook stuff. But sometimes it plays out like a full-blown corporate soap opera. Today, we're looking at a fascinating piece of source material, Constitutional Court Case CCT 15/02. It's a case that fundamentally asks what actually happens when the people elected to run a government completely forget how to work together.
So, picture this. You and your boss have a disagreement at work. Normal, right? But imagine your boss taking that mundane office disagreement straight to the Supreme Court, instead of just, calling a quick staff meeting. That's exactly the kind of situation we are looking at today. When colleagues in a regular workplace have a profound disagreement, they hash it out, they compromise, or, someone eventually gets fired. But in the world of high-stakes provincial politics, things can take a rather expensive and highly litigious detour. This whole case really forces us to ask a crucial question. What are the actual legal limits of a political disagreement?
Act 1. A house divided. To set the scene, our story takes place right on the periphery of the monumental Treatment Action Campaign case, the TAC case, back in 2002. Now, that was a massive landmark legal battle in South Africa regarding the government's provision of crucial medication. But this explainer? We're focusing on a completely chaotic sideshow that erupted right before a major hearing. Get this. We have two members of the exact same provincial government taking completely opposite legal stances on a major national issue. On one side, you've got the MEC, the member of the Executive Council for Health in KwaZulu-Natal. The MEC supported the appeal against the TAC. But on the exact opposite side, you have the Premier. The Premier is essentially the head of the province, which makes him the MEC's ultimate boss. And the Premier actively supported the tax application. So you literally have the province's top official and his own health minister grabbing the legal steering wheel and yanking it in completely opposite directions. You really have to picture the sheer absurdity of this courtroom scene. When the time came for the High Court hearing, two completely different sets of senior advocates showed up. Both teams confidently stood before the judge, and both claimed with a straight face to be the official legal voice for the province of KwaZulu-Natal. Just imagine the absolute confusion for the judge, and honestly, for the opposing counsel, trying to figure out who actually holds the legal authority to speak for the government here. It was a complete mess. Act 2, the Premier steps in. Unsurprisingly, the High Court had to step in immediately and put an end to this internal political chaos. I mean, the judge couldn't exactly listen to two contradictory arguments from the exact same client. A hard decision had to be made about who actually held the reins of executive power in the province for a legal dispute of this magnitude. And the court's dramatic ruling really hits the nail on the head. They essentially declared that the boss had officially usurped his subordinate. By stating, the principal has taken over, the High Court recognized that executive authority ultimately rests with the Premier. The MEC's independent legal representation was effectively canceled right there on the spot. The Premier was now firmly in the driver's seat. Now, in a normal workplace, this is where the story wraps up. The boss pulls rank, the employee grumbles a bit but falls in line, and everyone moves on. But instead of accepting defeat, the MEC decided to escalate this workplace squabble. Refusing to yield, he took an incredibly bold step. He totally bypassed standard procedure and appealed the High Court's decision directly to the Constitutional Court of South Africa. He was absolutely determined to fight his own boss at the highest judicial level in the entire country.
Act 3. The Constitutional Smackdown.
So for the Constitutional Court to even hear a direct appeal like this, they have to decide if playing referee is actually in the interests of justice. And let's be real, the Constitutional Court does not have the time or the resources to micromanage office politics. They were incredibly quick to point out a glaring flaw in this entire saga. In their judgment, they explicitly labeled this a purely political dispute. In fact, the source document references Section 132 of the Constitution, which points out a very basic fundamental fact. The Premier appoints the members of the Executive Council, and more importantly, the Premier has the constitutional power to dismiss them. If the Premier didn't like what the MEC was doing, he could have just fired him. Instead, they decided to clog up the national legal system. Which brings us to a foundational concept in Chapter 3 of the Constitution. It's called cooperative government. And it basically proves that playing nice with your coworkers in government isn't just a friendly suggestion, it's binding constitutional law. Organs of state, which absolutely includes both the Premier and the MEC, are legally mandated to operate in a specific,
cooperative way. It's built right into the system. When you look at these clauses, it almost reads like mandatory couples therapy for politicians. It's fascinating to see the law explicitly demanding good behavior. Section 41 dictates that government entities must foster friendly relations, assist each other, and crucially, this is the big one, avoid legal proceedings against one another. The Constitutional Court firmly reprimanded both men for completely and utterly failing this duty. They bypassed every single one of these constitutional obligations to cooperate, opting instead for a very public, very expensive legal duel.
Act 4. A useless legal battle.
Beyond the frankly embarrassing failure to cooperate politically, the court delivered one final, fatal blow to the MEC's case. Even if the justices completely ignored the political nature of the fight, and even if they ignored the blatant breach of cooperative government, there was a massive logical hole in the MEC's legal strategy that made the entire exercise completely pointless. The justices noted that the relief sought had absolutely no practical effect. Why? Well, because the MEC was actually using the exact same legal team, the state attorney, and the same advocates as the other respondents in the main national case. Think about that for a second. Even if the MEC miraculously won this appeal against his premier, he had absolutely nothing new to add to the main TAC appeal. His legal arguments were already being voiced by his lawyers on behalf of the other parties. So the crucial takeaway here is that the highest court in the land looked at this case and essentially declared it a colossal waste of everyone's time. Neither the MEC's appeal nor the Premier's request to submit further evidence served any useful purpose whatsoever. The court made it crystal clear the judiciary should absolutely not be used as a blunt instrument to solve internal executive branch management problems. Because both politicians completely failed their constitutional obligations, the court handed down a very specific, very pointed ruling. Now, normally, the loser in a court case pays the winner's legal fees. But here, the court dismissed the applications with no order as to costs. This is basically the judicial equivalent of a parent saying, "I don't care who started it, you are both in the wrong." By making no order as to costs, the court left both parties to eat their own legal fees. It was a subtle but incredibly sharp punishment for dragging out a completely useless fight. As we wrap up this explainer, it really leaves you wondering about the everyday realities of governance. The Constitution explicitly demands cooperation, mutual trust, and the avoidance of lawsuits between government bodies. Yet this 2002 case shows us exactly how easily those rules can be tossed out the window just for political ego. It forces us to ask a final provocative question. How much time, energy, and resources are being wasted daily by public officials who simply refuse to follow their constitutional mandate to just get along and do the job they were hired to do?